Hi, everybody. My name is Laura Akins, and I'm here with Kim Martin today to have a presentation on special needs planning, which I know many of you have been awaiting. So we're happy to do another presentation in our Planning for Peace of Mind series. And before we get started on this one, I just wanted to give you a heads up that we're going to be doing another presentation in December on probate and estate recovery. So just keep that on your radar. We have not set a date for that yet, but we will send out information in our newsletter on that. We'll also post on Facebook and all those things. But if you have signed up for this presentation today, you'll get the newsletter. You can always opt out if you want to, but that's kind of how we're getting the information out. So be on the lookout for that. Heather Nadler will be doing that presentation, so it'll be a good one. And just to give you another little kind of heads up today, Kim and I are both with Nadler Biernath, you've probably seen us both if you've been watching these presentations. Nadler Biernath specializes in special needs planning, which we'll be talking about today. We also do elder law. We also do kind of the standard estate planning and probate work. The important disclosure, Kim, if you want to move on to the next slide, the important disclosure we always like to give is this is not to be considered legal advice today, and instead we are giving you hopefully some really good information for educational purposes. Something we like to remind everybody, this is going to be a recorded presentation that we'll send out after the fact. We'll also eventually post it. And so if you're watching this maybe years from now, potentially, just keep in mind that the information can change. So this is for our 2020 circumstances. And so before Kim gets into the kind of provisions of special needs trusts and gives you a little bit of kind of behind the scenes and how we're thinking about some of the planning techniques that we use when we're drafting a special needs trust, I want to explain a little bit about what is special needs planning and what are we doing. Frankly, the bottom line is special needs planning is for either families with a child with a disability or a loved one with a disability. Also, sometimes people with disabilities themselves come in for planning. And we are hoping to either establish or preserve their eligibility for public benefits. We also want to make sure that we're giving folks options so that in the future, if they become disabled or maybe they have a ton of money at the time that they come in to talk to us, but maybe in the future, we want to make sure that money doesn't create issues down the line. We can do special needs planning then too. And I think the main thing that we always like to kind of reiterate is that this is exciting for us because we're creating quality of life for folks. Benefits don't cover a lot of expenses, and having the planning in place can allow a person with a disability to have a really good quality of life that they may struggle a little bit without some extra funds and support available. And then, of course, the last little tidbit there was prolong the use of available funds. That's just important too, because of course, having the special needs planning and the benefits allows people to be able to use both and hopefully maximize both pots of money. So that's a good thing. All right, so I'm going to breeze through all of this. Something I didn't mention at the top, but be sure if you have questions to ask in the Q&A icon, which you should find at the bottom of your screen. I'm going to be monitoring the Q&A and we'll try to answer questions as we go along. So feel free to post your questions there. If we don't get to your question during the presentation, we'll certainly try to get to it at the end. If your question is very, very individualized, sometimes those are hard to answer. And so in that case, we may not get to your question, but we hope to get to as many as we can. Let's talk a little bit about what special needs planning is for. I mentioned that we're trying to preserve or establish benefits eligibility. So what are the benefits we're talking about? There's really two main types. The first is the insurance-based benefits we have on this slide. So those really generally fall into the categories of Social Security disability insurance and Medicare. So that's SSDI and Medicare. And so Social Security disability insurance comes either because a person has paid into the system because they've been working and they become disabled and they need to draw on their Social Security disability benefits, or for a child who has been disabled prior to age 22, they can draw on their parent's work record when their parent retires, becomes disabled themselves, or passes away. So that's an important thing. It's got to be the case that someone has been paying into the system with their work record. And again, for a child, when we're talking about a disabled child, they can draw on their parents' SSD, or they can draw SSDI on their parents' work record at the time that the parent retires, becomes disabled themselves, or passes away. And then the other really important component to SSDI is that after being on SSDI, receiving SSDI for 2 years, an individual receiving that benefit is eligible for Medicare. And so Medicare, regardless of whether they're over 65 or not, they can utilize the benefits under Medicare. And so that's really important. That's as opposed to these need-based benefits. So again, when we talk about SSDI and Medicare, we aren't looking at how much money someone has. We're not worried about assets or income. We very much care about assets and income when we're talking about supplemental security insurance and Medicaid. Okay, so that's SSI and Medicaid. And so SSI is a monthly income benefit to individuals who are either aged or disabled and they're impoverished. And so when we say impoverished, what we're saying is that they have low income and they have assets of $2,000 or less that are countable assets, and we're looking at the monthly asset amount. So when we say, do they have countable assets, we kind of want to know on the first of the month. It's not necessarily going to be all month long they have $2,000, but we always want to look at that. So again, SSI is going to be a monthly payment. Right now, the 2020 figure for that is $783 a month. That's the maximum amount you can receive when you're receiving SSI. And with SSI in Georgia, you also get Medicaid. Sometimes people can receive Medicaid without receiving SSI. And it's something just to kind of note that we hear Medicaid and we think medical care, but Medicaid can be there are lots of different kinds of Medicaid programs. There are different waiver programs that many of you may be familiar with that provide various supports and services for people with disabilities. There are a lot of different kinds, and so it's important to distinguish, but it is also good to know that with SSI comes Medicaid. And in order to be eligible for those benefits, you have to have $2,000 or less in countable assets and lower income. Okay, next slide, Kim. So when we're looking at special needs trust planning, what we're trying to do is consider how can we maximize funds over $2,000, right? So even if someone a parent may want to leave their child $10,000, which in the grand scheme of things is a lot of money, but it doesn't, it's not a huge amount of money. It still can disqualify a child for benefits. So how are we trying to plan around that? And the way we do it is we have money go into a special needs trust. And so there are two main types of special needs trust that we're working with. The first one is a first party special needs trust, which is going to be funded with first party money, or I'm getting some questions coming in, so I'm just going to pause that thought for a second because they're good ones. The first question is, if a child draws on SSDI, does that affect the parent's eligibility to draw on Social Security? Kim, do you want to answer that, or you want me to?
Either of us. I mean,
you go ahead.
The short answer is no. If you'd like to elaborate.
Yeah, right.
I'll let you.
You can go ahead. The answer is no, right? So a parent can draw on their own record and their child gets to draw on SSDI once the parent has reached the point, again, where they've retired, become disabled, or the parent's not going to draw on it if they have died, right?
In
So
fact, in some cases, you can even have 3 family members drawing based on one parent's social security record. You can get typically up to 175% of what one eligible parent is entitled to get in social security.
Another question we got is referring to a new trust law that's restricted the use of funds in a trust to 10 years. I think what this question is referring to is the new law related to retirement account distribution, which Kim is going to talk about a little bit later. So hold the question. There's not a new trust law per se. So I think that you're referring to what we call the Secure Act, and Kim is going to talk about that. So I'll hold off on that. Okay, so kind of backing up to special needs trust, the first party special needs trust is funded with first party money. First party money is always going to be any assets or funds that belong to a disabled beneficiary. So that can be an inheritance that did not go into a special needs trust. In certain situations, it could be child support. It could be a settlement because of an accident and the child is the beneficiary of that personal injury settlement, things like that. First party trusts are a little bit more limited than the alternative, the third party trust. So a first party, the beneficiary has to be under 65 when it's set up. And in a first party trust, only a parent, grandparent, parent, court or legal guardian, court appointed or legal guardian, or the beneficiary themselves can set up a first party trust. So that sometimes takes a little bit of planning ahead because we want to make sure that the trust can be set up if we need it. So first party trust, again, is going to be funded with funds belonging to, also that could be income funds belonging to the disabled beneficiary. That's as opposed to a third party trust. And a third party trust is funded with what we call third party assets or assets owned by anybody else, everybody else other than the beneficiary. We do a lot of third party trusts in our practice because this is a great tool for parents to move assets upon their death or while they're in life over. And so their disabled child can benefit from some of their funds while still being eligible for benefits. Something important to note that we've got on there is there's no Medicaid payback provisions for a third party special needs trust. For a first party trust, if a person is receiving Medicaid, that any money remaining in the trust upon the beneficiary's death will have to be paid back to Medicaid. So that's another kind of planning factor that we take into account. And then the other thing about the third party trust is once it's set up, anybody other than the beneficiary, that's the disabled person, anybody can fund a third party trust with gifts, or maybe the grandparents want to leave something for their grandchild or anything like that. That's just to back up real quick. Something else just to point out, when we're doing trusts, we can set up trusts that are living or testamentary trusts. The living trusts are pots that you set up while you're in life. A first party trust is always going to be a living trust. So it's one that you sign and it comes into effect. And the third party trust is going to be one that you can set up as a living trust where you sign, it comes into effect, it's a pot ready to receive funds. Or you can do what we call a testamentary trust, which is one that's in your will and it is set up upon your death. So it's a little bit less kind of settled and kind of locked in place, but it's in your will and it's also an option. So I'm turning it over to Kim now. She's going to tell you about all of these provisions that we can put in our trusts to make them sort of extra special planning techniques, extra special, pun intended.
Yeah. So thank you, Laura, for the quick but thorough introduction to the different kinds of special needs trusts. This is something that we have spoken about before for an hour. Everything that Laura just covered can take a very long time because there's so much information about just which trust is appropriate for the needs that you have. We did some brainstorming about the rest of this presentation, and I'm actually really excited that we get to do it because I've never gotten anybody to let me talk about my favorite trust provisions before. But that's basically what we're going to talk about for the rest of this session. The first one that I love having in trusts is something called a memorandum of intent provision. This is particularly nice to have in a third-party special needs trust. And as Laura mentioned, the third-party trust is really the classic estate planning trust. That's the trust that you would use to hold assets that you would leave to your child or for your child's benefit in your will. It would be the beneficiary of a life insurance policy or an IRA, which we'll get to later. So that's the trust that's probably going to hold a substantial amount of money to take care of your child when you're gone. And because it's going to be most likely funded when you're gone, I love to have a provision in the special needs trust that directs the trustee, if I've written a memorandum of intent, I want you to read it and I want you to do what it says. So what is a memorandum of intent? It doesn't have any particular format. There's nothing official about it. It's not a particular form. It can take any form you want. It can be a paragraph, it can be 20 pages, it can be a binder. But the goal of the memorandum of intent is for you to express your wishes to future trustees about the way you want the trust assets to be used. So if there's a particular type of therapy that your child has really benefited from, and insurance is calling it experimental, even though it's been in place for 30 years, you can say in your memorandum of intent, my child has always really benefited from hippotherapy or whatever. And I really want the trust to make it possible for him to keep on doing his hippotherapy, even if it's not covered by insurance. You can write about your wishes with regards to your child's medical care, different types of specialists that you think have benefited him or have not benefited him. But it's just a really nice thing to include in the trust because it's so easy at your end, at the parent's end, because you don't need a lawyer. You can write a memorandum of intent yourself. You can do it years after you sign your special needs trust if you want to. There's no deadline. You can change it anytime you want to. And in fact, I always tell people it's a good idea to revisit your memorandum of intent every couple of years and just make sure that it still expresses your wishes, because as life rolls on, your child grows and you grow and everybody's needs change and your intentions might change. So anytime that you want to change your memorandum of intent, all you have to do is write a new one, sign it, date it, and make sure that you attach it to the trust so that your trustee can find it. So another provision that I always include in special needs trusts, especially in a third-party trust, is the power to own a home. There are so many great things about this provision. It has to be worded properly because the rules that typically apply to a trustee as a fiduciary require that the trustee invest the trust assets in property that is productive. In other words, something that's going to make more money. If we don't need the cash to spend, we want the trustee to make that money grow so that it lasts as long as possible and is there to take care of our beneficiary for as long as possible. But of course, a house is not really productive property. In fact, it's property that costs money. So the provision needs to include a waiver of that duty to invest in productive property only in order for the trustee to be allowed to own a home. I always give the trustee discretion either to charge rent or not to charge rent. And that's really important, particularly if you have a child who is on SSI, because if we've got somebody on SSI, we don't want to give them food and shelter. A lot of you may be familiar with the rules that govern how SSI is supposed to be used for food and shelter. And if food and shelter comes from any source other than SSI, then Social Security will say you're getting in-kind support and maintenance, and they will reduce your child's SSI payment by 1/3. So the way to avoid that problem is, rather than giving your child food and shelter, you charge them for it. You create a room and board agreement and you charge them rent essentially to live in your house. You can do the same thing with a home that's owned by a special needs trust. So the trustee has discretion to charge the child rent. Another good reason to charge rent might be even if the child's on SSDI and the in-kind support and maintenance rules no longer apply, we still may want to keep that child qualified for a lot of the nice Medicaid waivers that are out there, which means we need to keep his assets below $2,000. So a great way to keep that SSDI bank account under $2,000 is to charge the child rent every month. It doesn't really cost the child anything because they're paying that rent into a basket that's there to take care of them. If none of those reasons apply, the trustee also would have discretion to just allow the child to live in the home without charging any rent. Another nice thing about having the trust own the home that the child lives in is that then we've got a fiduciary whose duty is to maintain that asset, meaning if the roof leaks, the trustee is supposed to know about it and the trustee is supposed to take care of it and get it fixed. The trust would then be able to use trust funds to pay for anything related to the upkeep of the home, anything from homeowners insurance to, new plumbing or new carpet or any other type of repair or improvement that the house needs. Another nice thing about having the trustee own the home that your child lives in is the trustee is then the landlord, which means the trustee can monitor who else is using that home. So if the trustee comes to visit the asset, which they're supposed to do periodically, and they find some random guy that your child met at the bus stop sleeping in the bathtub, the trustee can say, nope, you're not on the lease. You can't stay here. Out you go. So it gives the trustee the ability to sort of make sure that the home is a safe place where, only the things that should be happening are happening. Some families even go as far as to create a home that is approved as a group home by Medicaid. And if you do that, and sometimes more than one family will get together and create a group home. And that allows for certain Medicaid waivers to pay for a lot of supported living. So sometimes you'll have two kids who've known each other since they were little and now they're in their 20s and their parents get together and say, let's put them in a home and, it'll have enough bedrooms so that we can have either around the clock live-in care or, at the very least, somebody who's there 8 hours a day. And if you put enough hours together, because we've got multiple kids that are getting waivers, you can end up with a great deal of support that's paid for by Medicaid. So that's all long-term planning. Another provision that this is fairly new because these accounts haven't been around that long, but we always include the power to fund an ABLE account in a special needs trust. This is an appropriate provision for either a first-party trust or a third-party trust. If you're familiar with the rules around ABLE accounts, they're not necessarily the greatest place to put a whole lot of money, partly because there are limitations on what you're allowed to put in there, but partly because ABLE accounts are subject to Medicaid payback, just like a first-party trust is. So you don't necessarily want to put a whole lot of money in there, which is why this is always a discretionary power. So the trustee has the option to fund the ABLE account with trust money if they feel that it's a good idea. And the best source of the funds, if you have both a first party and a third party special needs trust, is probably going to be the first party trust, because the first party trust is already subject to Medicaid payback. So you're not really losing anything by taking first party trust funds and putting them into an ABLE account.
Can you briefly explain just what an ABLE account is?
Yes, I should have done that. An ABLE account, they were created, I believe, in 2017, so they're fairly new creatures. A lot of people are more familiar with the Section 529 college savings accounts. The ABLE account was actually created statutorily under Section 529A of the Internal Revenue Code. So it piggybacks on a lot of the 529 rules. And these are accounts that you can contribute to if you meet the definition of disabled that qualifies you to contribute to the account. there are limitations to how much you can put in and the nature of what you can put in. So you have to fund the account with cash. You can't convey stock or other property that has a value. It's just got to be cash. You can only put up to $15,000 a year into the ABLE account. The one exception to that rule is that if your child is employed and they're earning money, you can put in the 15,000 plus whatever amount the child earns up to the federal poverty limit for that given year. So this year, I think that's 12,000 and something. So the maximum that you could possibly get into an ABLE account this year would be 27,000 and change. So all of those requirements would apply to trust money that you put into the ABLE account as well. So a trustee would be subject to those funding limits, and the trustee would also only be able to put cash into the account. So the big reason to me that you might want to use an ABLE account as opposed to a trust account to pay for an expense that your child has is that in-kind support and maintenance rule that I talked about a little bit just a minute ago. So the rule is if your child is getting food or shelter from any source other than SSI, that's considered in-kind support and maintenance, and that's going to reduce your child's SSI benefit by a third. The one exception to that rule is if food and shelter costs are paid out of an ABLE account, that is not considered in-kind support and maintenance, so there's no 1/3 reduction. And that's really the greatest reason I can think of that anybody would go out of their way to put money into an ABLE account. So the downsides to funding the ABLE account, which is why we make this discretionary, we don't require the trustee to do it, is that at the end of the child's life, Medicaid will consider whatever is in the ABLE account to be part of the child's estate, and they'll seek estate recovery. So they'll seek payback from the account. And Georgia law has not explicitly addressed the issue of whether funds in an ABLE account are subject to conservatorship. I have had one probate court judge that was in Fulton County say ABLE account funds are not subject to conservatorship, but we don't really have any explicit guidance on this. So it's possible that if you have a child who doesn't have any assets that would be subject to conservatorship and you fund an ABLE account, depending on what county you're in and what judge you're in front of, you may have caused a need for conservatorship by funding the ABLE account. And that's just something that we don't have enough information on to say with any certainty. And then the most complex provision that we're talking about today is this provision that we have noodled over this a lot at the firm and have really thought hard about the way we've worded this provision. But we have a provision that empowers the trustee to own and manage an inherited IRA, which is not as simple as it sounds. The IRA rules are very complicated, and the rules that govern special needs trusts are also very complicated, and often those sets of rules are in direct opposition to each other. So you really have to step carefully if you're going to have a special needs trust own an inherited IRA. And the word inherited is significant here. We're not talking about an IRA that your child owns, because the child can't, or not only your child, no one is allowed to convey away ownership of an IRA during their lifetimes. So if your child has, a 401k plan that they get through their job at Publix, or if they've been putting money into an IRA since they were, able to earn the money and put it away, that money has to stay in the child's name as long as it's in the form of the IRA or a 401k. So the only way that you can convey that money away to a trust is to cash it in. So this provision really would be something that would be appropriate for a third-party trust, not a first-party trust. And this is a way that a parent can name the trust as opposed to their child as the beneficiary of their own IRA. So you're going to want to pay attention to your beneficiary designation wording. You don't want to say, I name my child as the beneficiary, because then you've caused it to become first party money, and it's just hopelessly first party, and we're stuck with that. So your beneficiary designation should read, to the trustee of the blah, blah, blah special needs trust, and put in the name of the third party special needs trust. So Laura talked about the Secure Act a bit, and this, I think, is the question that somebody was asking about the 10 years. The 10-year rule is part of the Secure Act. The Secure Act was passed at the end of 2019, so it became effective in January of 2020, and it changed the rules for the way inherited IRAs get treated. So under the old rule, if you inherited an IRA, you could, it's called stretching the IRA. You could use your actuarial life expectancy to determine how much money you're required to take out of that IRA every year. That's called the required minimum distribution, or the RMD. And it's because it's based on actuarial life expectancy. Obviously, if you're a younger person, your RMD amount is going to be smaller, which means you have a longer time that you can keep funds in that IRA. And that's significant to you as the person taking the money out, because when you take money out of a traditional IRA, so these rules don't apply to a Roth, but if you take money out of a traditional IRA, then that money is subject to income tax. So the longer you have to stretch out those IRA distributions, the better it is for you from an income tax planning perspective. So those are the old rules. Under the Secure Act, the general rule is, it's this thing called the 10-year rule. So if you don't meet one of the exceptions under the Secure Act, when you inherit an IRA from anyone starting in January of 2020, you have 10 years to take out all the funds in the IRA. So imagine that you inherit $1 million IRA and you're subject to the 10-year rule. That means your income, if you, assuming that you choose to space that out evenly over the 10 years, which you don't have to, but if you decide to do that, you have $100,000 in additional taxable income every year. So that's not ideal from a tax planning perspective. There are 5 exceptions to this 10-year rule. And the only 2 that really matter for our purposes are, if you're a surviving spouse, you can still have all the privileges that surviving spouses have always gotten with regard to IRAs. So that means you can take the IRA and call it your own. And it's no longer an inherited IRA, it's just yours. Or you can keep it as an inherited IRA, but either way, you can use your life expectancy to stretch out those distributions. The other exception that's a really big deal in special needs land, and that has in fact changed the way a lot of families are planning to provide for their special needs kids, is if you are a disabled person under the statute or a trust for a disabled person, you can stretch the IRA over the beneficiary's life expectancy. So if you've got, let's say, 3 children, and you have a lot of wealth in your IRA, and one of your children is a special needs child, so you're creating a third-party special needs trust for that child, it's really worthwhile to sit with a financial planner and do some math, because all of a sudden, your special needs child is the most tax efficient person that you could possibly leave your IRA to. Because if you divide it by 3, the 2 kids that are not special needs kids have 10 years to realize all the money in that IRA and to pay taxes on it. Whereas your child, or the trust for your child, the special needs trust that you should leave the IRA to, that the trustee can stretch that IRA over your child's actuarial life expectancy. So there's that benefit. And there's also the benefit of the fact that very likely, if you have a child with special needs, that's going to be the child who has the lowest marginal income tax rate in the family, probably by far. So this the Secure Act has really been sort of a game changer as far as special needs planning, because a lot of families are now deciding they're going to leave a lot of IRA assets to the Special Needs Trust, and they'll distribute their other assets differently to make up for that disparity in distributions.
Kim, one question we got that's kind of along those lines is, can a grandparent designate their IRA to a child? The question, I think it's important to note how it's written, because it says, could a grandparent designate their IRA to the child or the trust? You want to address that?
Yes, they can. It is always a bad idea to designate the IRA to the child, because then it's going to be first party money. But as Laura mentioned when she was talking about the flexibility of the third party special needs trust, assuming that you've done an inter vivos trust, a living trust, which means it exists when you sign it, then grandparents or anybody else can name that trust as the beneficiary of an IRA, which is a really good argument for doing a living trust as opposed to a testamentary trust. So grandparents or anybody could name a special needs trust as the beneficiary of an IRA. And it's probably a really tax efficient thing to do if they do decide that they want to do that. So there is a provision in the IRS rules that the IRA assets have to be paid for the benefit of the beneficiary. And what that means is you have to actually take out that required minimum distribution every year in order to satisfy the IRS rules. So that is in direct conflict with one of our kind of most fundamental special needs trust rules, which is we don't want to be handing out money to the beneficiary, or we want to use funds as they're needed for the beneficiary. But what if our required minimum distribution is more money than we need to spend that year for our beneficiary? So there is a way to navigate these rules. It's tricky, but it can be done. So what we do is the trustee takes the required minimum distribution in a fashion that qualifies it as taxable income for the IRS. So the IRS is happy if we just take the funds in a manner that triggers the income tax. Once we've made it taxable, the IRS doesn't care what we do with it. We can roll it up and smoke it as far as the IRS is concerned, as long as we've triggered income tax, because that's what they're interested in. So we can take the distribution for income tax purposes, but for special needs trust distribution purposes, the trustee can create a separate bank account still under the umbrella of the special needs trust, and can just put any unneeded distributions from the IRA into that separate bank account, so that we're not making distributions to our special needs trust beneficiary, which would cause issues at the benefits end. So, and the only other rule that I was just going to mention is the trustee has the discretion to determine in some cases whether something is going to be treated as income or principal. And the trustee would just need to be aware that the income from the IRA has to retain its character as income. So we can't recharacterize it as something else, because that might make it exempt from income tax. So we're trying to walk this very fine line with these IRA distributions and make sure that we satisfy the IRS by causing these distributions to come out in a way that they are taxable income, but we also keep within the confines of our distribution limitations as special needs trust administrators. So this is a really complicated provision that we could talk about forever and a day, but the bottom line is, as long as you've got the right provision in your special needs trust, a special needs trust can own an IRA and can stretch it, which is a really big tax planning deal these days. We have some additional information up here that I'll just leave up long enough for people to copy it or take a screenshot or whatever. But one of the things that we have here is a resource about the Secure Act that's on the IRS's website. There's also a link here for the Georgia Stable account. So if you want to read more about ABLE accounts, in Georgia, they're administered through Ohio, and so they're called the Stable account, and that's the website where you can go and read more about the rules and the parameters of stable accounts. And of course, we have the Nadler Biernath website where you can find all kinds of good things, including, I believe, eventually all of these talks. So I believe that we're now at question and answer time. Do we have any questions, Laura?
We have a few. We don't have a ton, so if you have questions, kind of send them in and we can try to get to them and still wrap up before and take everybody's time into consideration. Somebody's just asking, can we get a recording of this meeting? And you will, because next week is Thanksgiving, it should be next week that you'll get a message and access to the recording of this video. But if it's not next week, it'll certainly be the first week of December. So look for that. I think a good sort of just kind of intro question that someone is asking, Kim, is how do you know if your child actually qualifies for a special needs trust? For instance, does someone with a diagnosis of autism qualify?
Well, it doesn't really matter what you're diagnosed with, and you don't have to qualify as far as, you could create a special needs trust for anybody. And if you guess wrong, let's say you have, a very young child and you're not really sure whether they will someday be self-supporting or whether they may want to qualify for benefits or need to qualify for benefits. There's not a rule. You don't have to meet any particular criteria to create a special needs trust for someone. So
outside of the fact, I guess the only caveat I would put to that, Kim, is that in order to sort of meet the standard for Social Security, the person has to qualify under the definition of Social Security's disability.
Sure.
That
is, yeah, I mean, the child has to meet the definition of disabled in order to qualify for benefits.
But that can be an
but as far as the creation of a special needs trust, if you don't know yet whether your child is going to meet that definition someday, you can create a special needs trust. There's no penalty for doing that.
Right. Another question is there a table that shows the limit of income for a household and SSI not be affected? The follow-up to that is, how can I protect my child's benefits if I get married and new income comes in? So do you want to clarify the SSI benefit there, Kim?
Well, if your child is over the age of 18, Laura, tell me if I'm answering the question properly. Am I going in the right direction? Okay, so once your child turns 18, he becomes a household of one for benefits purposes. And what that means is, even if he still lives with you, even if you completely support him financially, at the age of 18, Social Security stops paying attention to what you have or what dad has or what anybody else in the family has, and they only pay attention to what your child has. So as long as your child personally doesn't have more than $2,000 in non-exempt resources, they will qualify. At least they will meet the means test to qualify for SSI. Does that answer the question, Laura? Do you think?
I think so. Let me know if it doesn't, but I think so. I think the bottom line there is, once a person turns 18, that Social Security benefit is based on their own assets. So it doesn't matter what happens as a parent to your financial snapshot. Along those lines, there's a question: if a child has SSDI, can he also draw on the parent's Social Security? I think.
So, in other words, can you get SSDI from two sources?
Well,
do you think that's what the question is?
So I think the answer to the question of if a child has SSDI, can he also draw on a parent's Social Security? I think the answer is that he is. Your child is drawing on your Social Security record.
Well, potentially, what I'm thinking is, I know every so often we'll see somebody who has a work record of their own, like a young adult disabled person. So they may draw SSDI based on their own work record, and they may be getting, let's say $200 a month in SSDI based on their personal work history. And then the rest of they would get the remainder of the SSI would still be paying. But then if a parent retires and begins to draw Social Security, the child could potentially get their own SSDI based on their work record plus SSDI based on the parent's work record.
Right.
Just depending on how the math works.
Another good question we have is, would you clarify the term of special needs trust? I went to a lawyer and received a living trust in my name with instructions to oversee my son's need. Are these the same?
Well, a special needs trust can be a living trust, but if what you have is a revocable living trust, that is not a special needs trust. It's possible that you have a revocable living trust that has a special needs subtrust in it for your child. This is one of those, it's really hard for me to answer this question because I haven't seen the trust. So I'm taking my best guess here. But if you have a trust that holds your assets now while you're alive and manages them for your benefit until your death, that's probably a revocable living trust, which is not a special needs trust. But it's possible that you've got a provision in that trust that says, at my death, fund this special needs trust that exists within the living trust.
I think just to piggyback on that, that's sort of the idea behind this presentation today, is we are finding that there are a lot of lawyers out there who do really good work as estate planners, but they don't necessarily really know about special needs planning or how to do it, because as you can see from the presentation, it's somewhat complex. And so this is what we do kind of regularly. And so we find sometimes lawyers will be handling the estate planning component for a family, and they'll pull us in to do the special needs planning part of it. Sometimes families have us do everything. And then sometimes people just are not aware that special needs planning is a thing. And so it's just, we're happy to be educating people about this because a lot of lawyers don't. So that would be something to confirm for your, maybe from your lawyer, that they did actual special needs planning for you and not just a revocable living trust. Another question that we have is, and I think this is a good one, is if my special needs son dies, assuming that the special needs son is a beneficiary of a special needs trust, can the other two children be secondary beneficiaries of the assets in the trust?
Sure they can. So it's assuming that this is a third-party special needs trust. That's what this sounds like. It's a sort of a conventional estate planning trust, a third-party trust. One of the nice things about creating a third-party special needs trust is at the death of your child, there's no Medicaid payback. So those assets that are remaining can go wherever you say they go. So you can direct those assets to your other children or to a charity or wherever you want.
Someone else is asking, I'm buying a home. Can I place the home into a trust? And then a second person asked, well, I guess that's a separate question. We'll start with the first one. I'm buying a home. Can I place the home into the trust?
Sure you can.
Yep, that's a great answer. And that's something that it'll depend on the circumstances as far as what other funds you have to support the home and what needs your special needs child may have, but that's certainly something you can do. Another question is, where is the trust actually housed? Is it with a law firm, a bank? How does that work, Kim?
Well, I mean, a trust is really sort of a theoretical basket, and it holds whatever you put in it. And you put stuff in it by titling the stuff in the name of the trust. So you could have a special needs trust that owns a home, for example. The trust would own the home because there is a deed to the house, and the deed says this home is owned by the blah, blah, blah special needs trust. The trust could have a bank account, which means you have a bank account out there wherever you've decided to have a bank account that says this is owned by the trustee of the blah, blah special needs trust. So the trust doesn't physically live anywhere. I mean, the actual pieces of paper that create the trust are things that you should keep somewhere safe. but
That's the trust agreement. So you'll
the
sign a
trust
trust
agreement.
agreement,
Right.
right?
The thing that you sign to create the trust is a physical bunch of paper,
Mhm.
and you need to keep that safe somewhere. But the things in the trust are there by virtue of being titled in the name of the trust.
Someone else is asking, are special needs trusts transferable from state to state if the beneficiary moves?
Very likely, yes. In Georgia, Medicaid has to approve every special needs trust. And Georgia has its requirements, and those requirements do vary from state to state. I don't think there's a huge variation in requirements, but it just depends on where you're going. But wherever you go, you'll very likely need to submit the special needs trust to the Medicaid office within that state for approval. As long as your trust is revocable, which our third-party trusts typically are, unless we have a good reason not to make them revocable. If you move from Georgia to some other state and the Medicaid office in that other state says, oh, but we need you to have this provision, you can do an amendment and you can add it. So, and very possibly you won't have to do anything. So a special needs trust typically will travel with little or no modifications.
Something just to follow up on that, though, is it's important to remember that benefits don't travel. So if you're
Right.
receiving Medicaid in Georgia, so our trusts are drafted for the Georgia benefits and for the federal benefits. But if you move to a different state, their state rules may be a little different. So sometimes, depending on the situation, we encourage people to get the trust reviewed just in case. Another question that I think probably applies for different people, because this is a common question with our clients, is let's say your special needs child has cash gifted to the child. And this person is saying he wants to buy stock in the child's name. Do I buy stock instead in the name of the trust? And so how would you go about answering that? I think the first thing I say is it depends a little bit, but sort of the overarching circumstance of if your child gets some money in his name, how do you deal with that? And what do you think about that?
Well, I mean, we must have said it depends 6,000 times today, but it depends on how much money it is and on whether you want to fund an ABLE account, if assuming it's less than $15,000, or whether you want to create a first party special needs trust, which will give you a lot more flexibility and will also hold any amount of money. So assuming that it's enough money so that you feel that it's worthwhile to create a first party special needs trust, you can put that money in there in the form of cash. And then as trustee, you or whoever you designate as trustee can buy stock or, invest in a mutual fund or make any type of investment that seems like an appropriate investment.
Another question is, if Medicaid approves special needs trusts, which we do get our living trust established by Georgia Medicaid, but the question is, if Medicaid approves special needs trust, is that only after the trust becomes active, i.e. the parents die and the trust gets assets? So maybe, yeah, you go ahead.
Do you want to answer it?
I was just going to give you, you can go for it, Kim.
Okay, so a trust, I mean, if you have a testamentary trust, a trust created under your will, you don't really have a trust until you're dead. So Medicaid is never going to see that trust or know about it until you're gone. And then it exists, and then Medicaid would approve it. If you create an inter vivos trust, a trust that exists during life, so it exists the day you sign it, then in theory, it will have assets on the day you sign it because it'll have what we call seed money. So you'll just fund it with $10, but that $10 it's an asset that the trust owns. So if you create the trust that exists during your lifetime, that exists when you sign it, then that trust can and should be submitted to Medicaid right away, and they can approve it while you're alive. They can approve it with $10 in it.
And that's just another reason that we sometimes, again, very much depending on the circumstances, encourage people to do a living trust, because they can go ahead and sign it, get it set up, and it's ready to be funded. And also we can go ahead and get it approved by Medicaid, and that can be a good thing, depending a little bit on your circumstances.
Agreed.
Another question is, does the beneficiary assets that are not in the trust, so if a special needs person owns money and it's not in a trust, do those count against him for getting his own SSDI?
Well, SSDI doesn't have a means test. So SSDI doesn't pay attention to how much the beneficiary has in the bank or in any other form. But there are other good reasons to meet the means test. So even if you're on SSDI, there are all these nice Medicaid waivers, like the Now waiver and the Comp waiver, and some lesser Medicaid waivers that do depend on your ability to meet the means test. So as far as SSDI is concerned, you can have more than $2,000 and it doesn't make any difference. But there are other reasons why you still would probably want to be careful to pass the means test if you can.
We got a question that I think is trying to clarify how an ABLE account works in conjunction with a special needs trust when it comes to paying for housing. This question is asking, she's a bit confused about the fact that, first of all, just to kind of give a little background for the question. So an ABLE account can pay into a third-party special needs trust. When you are,
the other way around, the third-party trust can pay into an ABLE account.
Right, sorry, yes. If you have conservatorship under a court, the court is not going to be interested in the funds in a special needs trust. That's another benefit of having a special needs trust, is the trustee of the trust is managing that money, not the conservator. So we aren't going to be reporting to the court. And that's part of this question, is she's a little bit confused about how to deal with conservatorship, ABLE account, and a special needs trust. And I think it's maybe worth just reiterating how an ABLE account can be used to pay for housing if a person is still receiving SSI, let's say, because again, remember with SSDI, we're a little bit less concerned about that reduction in benefits because it's not a means tested benefit. So Kim, to boil down the question, how does it work for an ABLE account to pay for housing and not lose any reduction in the means tested SSI benefit with a third-party trust?
Okay. So let's say, I'm trying to think of a hypothetical to apply rules to. Let's say that your child lives someplace that they're paying, let's say they're paying $1,000 a month in rent. Well, SSI is only $783 a month. So obviously there is absolutely no way for SSI to meet all of that child's food and shelter costs. It can't be done. It's not enough money. So that money, the extra money to pay the rent, the excess rent, has to come from somewhere. If we use our special needs trust to pay that excess, Social Security is going to say, you're getting food and shelter from some source other than us and other than an ABLE account. So we're going to give you a 1/3 reduction in Social Security because you're getting in-kind support and maintenance. So instead of paying the excess rent out of the trust funds, the trustee could instead fund an ABLE account. This is basically like money laundering, except that you're allowed to do it. So the trustee would fund the ABLE account with trust money, and then the ABLE account would pay the excess of that $1,000 a month in rent. And because the funds are coming out of an ABLE account, Social Security is not going to say, oh, this is in-kind support and maintenance, and there will be no 1/3 reduction. Does that make sense, Laura? Do you want to take a whack at it?
I think that's the bottom line.
Best I can do.
I think the questioner was getting a little bit bogged down potentially in some of the rules of conservatorship versus everything else. And the kind of the bottom line is we're a little bit unsure of how conservatorship applies to able accounts because they're new and that case law is evolving. But something that's very good to know is that able accounts can be used to maximize an SSI payment if you're using it in conjunction with a third-party special needs trust. We're coming up on 12:30, so I want to again respect everyone's time. Last question I'm going to just answer really quickly because it's a quick one is, does your law firm have trustees? We do not. That's a difficult job and we can help you in part of our consult process resolve that issue, right? So figure out who's the best trustee, how do you figure out successor trustees if you can't serve? That's something that us or any other lawyer should give you advice on. The last, I think, kind of important thing to answer is just pricing, because several people asked about the price. And again, the answer, unfortunately, is a little bit of it depends, because it depends on how you do your estate planning. So you know is that if you come to our office, we're going to want to at least have a general idea of both the special needs person's assets and their sort of snapshot, but also in many cases parents, because your assets are going to matter to us. So the bare bones kind of minimum amount for that is going to be about $1,900, and then it can go up from there just depending on your circumstances. But of course, you know we would consult and give you a quote before we charge you lots and lots of money, which we would not want to do. I think that from there, most of these questions have either been answered or hopefully we touched on them at least. If you have other questions and we didn't get to them, or I know a couple of people are looking for referrals for Social Security appeals, certainly contact our office and we can try to answer those. Again, be on the lookout for the recording of this presentation, which we will send next week. You can enjoy it with your family while you're all Zooming and for Thanksgiving. And look out for our next presentation, which will likely be somewhere in the range of middle December, certainly before the holidays get going. And thank you all for participating.